presentation, but the second item is to do a brief introduction of the team members who are here. So I'll start from myself, then we go this direction. My name is Geoffrey Omesa from Client Services.
I'm Kelvin Bogua from Client Services.
My name is Val. I'm an investor and a CRC member.
My name is Charles Wambua. I'm an investor and chair of CRC.
I'm Pastor Ephraim Karangi, the vice chair, and I'm an investor.
My name is Anthony Lashan. I'm an investor. I'm also the legal advisor to the CRC.
Good morning once again, creditors. I'm Victor Uma from Cytonn Distribution and as well as CIM representative to the CRC.
Morning, creditors. I'm Dennis Kibet from Cytonn Investments Department.
Morning, everyone. I'm Jerry from Cytonn Real Estate.
Morning, Adams Dudi, Legal.
Morning, Celestine Koile, Legal.
Good morning, Henry Obunde, Kenda and any advocates assisting the CRC.
Okay, thank you very much. I am hoping that the team online, you are able to see my presentation. Somebody to confirm if you are able. Okay, somebody is saying no. Let me reshare again. Let me restart again. Sorry for that. It's logged interview. Oh, are you logged in? You can assist at the meeting. I can send to the waiting room. Now, somebody to confirm, please.
Hello.
Yes, are you able to see my screen?
Yes.
All right, thank you. Okay, now, thank you for joining this meeting. We have already done the introduction. Now we are going to, sorry, this is all good. Go on. Let's see. Confirming it is moving. All right. Okay. Sorry for that. Thank you for being patient with us. So we have already today's meeting. We have already done prayers, introduction. The second part we are going is DSP presentation, which will be done by Victor. Then we shall do.
I said I can't see you.
They can't.
Your video is
No, it's
off.
okay. My video is on.
Yes.
All right.
Just click on the,
Zoom, good.
not the PowerPoint, your video.
All right. All right. So, is it still there? All right. Okay. Sorry.
Victor now.
Number 4, we go legal updates. That will be done by Mali. Then the second part will be done by KDH. That is Stephen. Then number 6, we do CRC updates. That will be done by Chairman, assisted by Leshan. Then we'll go to item number 7, AOBs. Also, we'll combine with question and answer. Then we do adjournment as we finish the meeting. So kindly feel welcome. And now straight to the point, I welcome Victor to do the brief presentation of the DSP.
Okay, thank you, Mesa, and thank you, creditors and the CRC members for today's meeting. So we are going to look at the restructuring plan, just a summary bit of it. We'll leave most of this on for Q&A. So we're going to look at updates, the restructuring plan itself, and the suggested way forward. The reason why we are doing this is because of 2 things. The first one is that a liquidation is not in the interest of the HYS and CPN investors, because it will take a couple of years to only get 14% based on the analysis that has been done by our investments team. And the second one is that the orders were not obtained with the consent of the creditors, and hence that's why we are in the process of setting it aside. We'll go to the next. So these updates in terms of what happened this year, the CRC team, the Creditors Restructuring Committee, met with the official receiver on 13th March this year and expressed their interest to restructure that rather than to liquidate. And sadly, the OR is not seeing that as a way to resolve the HYS and CPN matters. Just back a bit. The other update is we had a number of clients totaling to 366 million who wanted preferential treatment in terms of settlement of their debt. We went to court and obtained stay applications last year on April 23rd. We still believe that this restructuring plan, which gives 10%, 100% return of principal in comparison to liquidation, which at best can only give 14%, is the best way to go, because it will dwell on 2 things. One is completion of projects, the 3 of them, and the other one will be returning money back to HYS and CPN investors. We have received unsolicited interest in both our shares in Superior Homes and Kilimani Land, which shows that the project that we have are profitable. So we need to find a way of how we can best sell them and return money back to our investors. For the litigation updates, I'll leave it to the team, which will be doing that at the tail end of it. So there is a reason why we are supporting restructuring as an alternative to liquidation. There are 4 reasons why we are supporting that. The first one is that the CIM, which is the principal partner in this matter, is giving this proposal recognizing that the funds and the projects are linked together, in the sense that whatever happens to one arm of the relationship affects the other. Because case in point, if we look at the ALMA, it has received it has continued to receive funding, but it has not been sufficient to really bring it back to profitability. So the best way to do this is to restructure so that we get the best out of it. The second reason is that the second reason. Sorry. Yes, I need to fix something. Okay. Apologies for that. So the second reason is that since the outbreak of COVID-19, operations around the vehicles that were funding projects really reduced by 96% in less than 6 months. And so this had a knock-on effect, as I've told you in the previous point, is that there is a relationship between the projects and the funding vehicles. So that reduction in inflows really affected on how the ability of us completing the projects, selling them, and returning money back to investors. So the best way to go about this is to restructure so that we ensure that we get the best out of this for investors. The third reason is that since the outbreak of COVID-19, operations around the project to support the interest accruals really were brought to a halt. And so we are going to propose a waiver of interest for the 2 years, totaling to 3.7 billion. I'm going to itemize this in the following slides. The fourth reason is that once we do the waiving of the interest for the 2 years, it will strengthen the balance sheet of the various projects, and that will enable further funding, which will bring around about liquidity on the project, and by the extension, our ability to pay back the HYS and CPN investors. So those are the four reasons why you are saying it's good we go the route of restructuring as an alternative to liquidation. So in terms of what is going to be done, just a snapshot look at it. We are going to sell the Superior Home shares and immediately pay 50% of the proceeds to HYS and CPN investors, and the rest goes to completing the ALMA, and that will mean that we are going to complete the ALMA and be able to sell and pay out the SBM loan, and also remain with some amount to pay to HYS and CPN investors. The other one is we sell Kilimani land, pay 50% to HYS and CPN investors, and then 50% goes to completing the Ridge. So once we do that, we complete the Ridge, the ALMA, we pay 50% to creditors, and the other goes to Taraji in terms of developing it. We complete Taraji and we pay 50% to HYS and CPN investors, and then the rest goes to developing the Riverrun to be service plots. Then complete the Ridge and pay 100% to creditors. So if you look at it, the net gain of it will be a higher value in terms of what we can be able to get out of this, and I'm going to itemize that in the subsequent slides. So when we do a comparison, this is the workings I've talked of. We are going to waive the interest for the 2 years, totaling to 3.7 billion. And what remains, we put it in two parts. The first part will be debt component of restructuring. The other one will be equity component of the restructuring. So we propose to do the payouts of starting 2025, 2026, 2027, and then 2028 in the manner of 20% in the first 3 years, and then 40% in the last year. What I need to mention is that this is dependent on a number of factors. The first one is our ability to resolve issues at the court, or in case of consent agreement, if whatever comes first, and also access. But fundamental how it's going to be done, it's just going to be as I've just stipulated there. So this is an example of a client who had a balance of 1.3 million by the end of August 2021. So we're going to waive the interest of the 2 years, totaling to 360,000. We remain with $1 million that we restructure it in two parts: 50% equity and then 50% debt to pay over the timelines that I've indicated there from For the 4 years, 20%, the first year, 20%, the second year, 20%, the third year, and then 40% the last year. So a comparison between restructuring plan and liquidation, if we are just to look at what has happened at River Mining, it took over 4 years, the liquidation, and investors only got 6.78% of their value. This is a very big haircut, which in our estimation, as I'm going to elaborate, based on the numbers that we have, restructuring will give at least 100% of your principal, whereas on the other side, liquidation at best can only give 14% of your value. And I'm going to elaborate this in the subsequent slides. So in terms of liquidation, if liquidation was to proceed, the first 4 projects won't yield anything to HOS and CPN investors. The reason being, for the ALMA, it's an incomplete project and it has an SBM loan. And if it's liquidated as incomplete status, all proceeds to go into paying SBM loan and other secured creditors. The Upload is sold out 95% plus and also has other pending liabilities. And so in terms of liquidation, investors won't get anything out of it. Newtown, this is a joint venture agreement, 1,000 acres, and has also other litigation issues to go through. So in the event of liquidation, nothing will be realized to HOS and CPN investors. For the Ridge, it has a loan of 3 billion and other pending liabilities. And so in liquidation, nothing is expected to HOS and CPN investors. So the project that can be able to earn some amount to HOS and CPN investors, which will bring in around 2.1 billion, would be the River Run, Taraji Heights, Kilimani, and Superior Home Shares, as well as Side Suites. And if you want to factor in the cost of liquidation, which we estimate at 5%, that will less the value further by 109 million, which we see the net realizable value coming out of 2 billion. So when we compare this with the 14% liability attributed to HOS and CPN, not factoring in the interest accruals for the 2 years, that will bring in a 14% return. So this is how we are getting the best scenario that investors can get in liquidation is 14% of their value. So I've spoken about this, having covered the other slides, so we'll move. So in restructuring, we propose to do a number of things. First is to complete the 3 projects, that the ALMA, the Taraji Heights, and the Ridge. And as we complete that, we'll be able to add value to them so that we can be able to get more out of it to pay back to HOS and CPN investors. The timelines of that will take 6 to 7 years because it will take some time for us to complete the projects I've mentioned and sell them out and return money back to HOS and CPN investors. We also expect, we envision for some HOS and CPN investors to move to a new company, which workings of this will be elaborated as we go on. The creditors to waive the interest for the 2 years, 2020 and 2021. I've mentioned the underlying assets which supports the investments were not adding value during those periods, and so it will be prudent for us to waive the interest for the 2 years so that we have a balance sheet that is strengthened. So in terms of relationships, during restructuring, there are 3 particular relationships that are going to resolve. The first one will be between the HOS and CPN investors and the structured products. The other one will be between the projects and the structured products and the creditors and HOS and CPN. Then for the first relationship, as I've mentioned, we waive the interest for the 2 years. Reason being, there's no much that was being done around the project to support the interest accruals. Then we terminate the current HOS and CPN and replace with equity instruments, that's 50% in equity and then 50% debt. Then for investors who are keen to moving the investments to a real estate of choice, that will also be available under restructuring. The other relationship is we reconcile the loan balances, that is HYS and CPN, based on the ongoing assignment. So that means if a client has moved from HYS to a real estate of choice, the HYS bit has reduced by the amount that has moved to the project. The other relationship, if you may, the other relationship is we are going to repay the existing loans on the SBM at the ALMA and the KCB at Site Suites through the restructuring process. And then in the event of a new company, then all underlying assets will be put under the new entity. The other one is the new instruments to include 50% equity in the new company and the remaining 50% to be a debt portion of the restructuring. To have the representatives of the funds, in this case, that would be the CRC, and then to do the overseer role in terms of the things that are being happening, then appointment of an entity or a person to undertake as well the overseer role in all this. So looking at this, I see there will be a lot of control in terms of how things are being done in the restructuring process. There's a lot of transparency, and as well, there is a lot of accountability. So this is the value of the projects as of today, that's 8.7 billion. And so when we let the projects go through the restructuring process, we expect them to bring, next slide. We expect them to bring 11.1 billion. And so when we compare the 11.1 billion with the HYS and CPN debt on the next slide. So when you compare as of 31st December 2022, the HYS balances were 10.2 billion, the CPN 3.9 billion. So the interest that accrue for the 2 years that we are going to waive are 3.7 billion. So if you net off, you're going to get 10B in terms of what is attributed to HYS and CPN. So how about the cash flows during restructuring? We're going to do out. We start with the sales base. So we sell the Superior Home shares. Part of it goes to completing the ALMA. Part of it goes to paying back investors. Then the other one, Climaniland, same thing happens. Part of it goes to paying HOS and CPN creditors, and part of it goes to completing either of the 3 projects. So that will lead us into now being able, even as we complete those projects, we'll be able even to buy back the shares that the investors have subscribed to in the event of restructuring. So in essence, that is what's going to happen to realize cash flows for the restructuring process. This is a pictorial look of how that will pan out. As I mentioned, the first year, 20% of the amount, the second, 20% of the amount, the third, 20%, and then the last, 40% of the amount. So these are mentioned under the ramifications of liquidation, so we can pass. We also have other stakeholders in the whole arrangement. We have apologies for the that it's not looking quite well, but we're going to fix that. We also have the ALMA contractor. We have okay, I'm just starting to come down. We have the ALMA contractor, the REACH contractor. We also have also homeowners who are in these conversations. So for the homeowners, they have done the applications in court so that they safeguard their status. For the ALMA and the REACH contractor, we are having conversations with them so that they resolve their debt as we did for the Taraji contractor. We pay them in kind. They can choose to take an apartment or a plot based on their preference. For the ALMA contractor, the settlement of their debt will be the same way we will settle the SBM loan. So we complete the projects and we'll be able to sell and return money back to them. So what are the issues that we need to consider? First is time is of essence, because as projects stay underdeveloped. There are many liabilities that are accruing, such as the SBM loan at the ALMA. As we talk, it is still accruing interest, so that in itself it is eating into what can be realized to HOS and CPN investors. So it's prudent that we do this process in a faster way so that we realize the best value to HOS and CPN investors. The other one, we are looking for a possibility of a buyout investor. This can only happen if we are able to take care of our issues that are happening as right now. If we can be able to coalesce together all the creditors so that we talk the same language, that will be easy even to approach our buyout investor so that we get the best out of this. The litigation, most of the clients putting themselves first. We've done some stay orders against them. As I mentioned, we did one last year on 23rd of April for clients who wanted to put themselves ahead of others. We've been having group sessions with investors such as this one. In case you want a one-on-one meeting, we are available. So what you can do, just do an email to clientservices@cytonn.com, and then you'll be able to reach out and agree on how we can have a conversation further on this. In terms of negativity, it's hurting the whole process. So I believe that not much can be got from anything if it's mad with negativity. So it's good we handle these issues in a way that realizes the best for all of us. In terms of options for investors in the restructuring plan, in the restructuring process, the first one is to stay on the cost the way I've just said. You wait out on the payments for the 4 years, 20% in the first year, 20% in the second year, 20% in the third year, and then 40% in the last year. The other one would be the assignment for a client who is keen on moving part of his investment or her investment into either of the projects, that will also be available. And this, of course, comes with a top-up based on the term sheet of the various projects. As I mentioned, under issues to consider, there is that issue of a buyout investor. This can only happen if we have made our case well, and we'll be able to get a buyout investor. And of course, this will come, of course, with the terms and conditions around it. So in terms of updates, we'll have our teams to do that from Mali first.
Thank you, Victor. Now we proceed to litigation updates. We start with our airport team from Mali Advocates. So you are most welcome.
We'll go through the litigation updates. So we'll start with the High Court matters. For the High Court matters, we have the insolvency petitions E063 and E064 in the matter of Cytonn High Solutions and Cytonn Real Estate Project Notes versus the official receiver. So in terms of the update, as at now, we filed a recusal application on the 11th of March 2024, seeking the recusal of Justice Mabea from determining all Cytonn matters on the basis of bias. The ruling of the application will be on the 28th June 2024. So the ruling on the recusal application, the directions for the other pending applications will also be issued on the 28th June 2024. That will include the CPN creditors application, the CHRS creditors application, the ALMA application, the Applewood homeowners application, EPAZEC application, CAP 10, CAP 11, CAP 20, CAP 4, and the Ridge Unit owners application. We've also filed an application under Section 491 of the Insolvency Act. This seeks that a meeting be convened by the creditors to discuss the debt settlement proposal, which we have filed in court. We've also then filed another application dated the 15th April 2024 under the Section 438 of the Insolvency Act. This questions the manner in which the official receiver assumed his duty under under the Insolvency Act. It also requests for the removal of the liquidator, who is the official receiver. All the two applications are coming up for mention for directions on the 28th June 2024. For the Court of Appeal matters, we have filed various appeals and applications seeking the stay of execution of the rulings given by Justice Mabea on the 30th November and the 17th January. So the applications and the appeals that we have filed are on behalf of Kilimani, where vesting orders were issued upon the official receiver, Alma, where a consent order was allowed as an order of the court, giving SBM Bank the leeway to exercise its statutory power of sale over the Alma and to give the proceeds, the remainder of the amounts after they've settled the principal and the interest to the official receiver for distribution among the creditors. Then there's the Alma homeowners application on behalf of the various Alma homeowners. There are two applications for Cytonn Investment Management, PLC, and then there's the goal advisory application. This is concerning the registered security against the Alma. And then there's the CHYS creditors application through the CRC. Also concerning the creditors, and there's the Riverrun appeal concerning the vesting orders that were issued to the official receiver on the Riverrun property. There's also an appeal on behalf of the Riverrun unit holders. So we had initially also filed two applications against the ruling of the 6th January, which then granted liquidation orders against the two funds. So this was the civil appeals 424 and 425. They were filed on behalf of Cytonn Integrated Project, which is the Alma. We also filed an appeal on behalf of Superior Cytonn Investment Partners 15 LLP, which owns the shares at Superior Homes Kenya. So as an update, the appeals have all been filed. We're awaiting directions from the Court of Appeal on the filing of written submissions, and also we are waiting for dates from the Court of Appeal, hearing dates for our applications for stay of execution. In the matters that are filed before the Court of Appeal, we are led by Senior Counsel Paul Mwite, who has severally written letters to the President of the Court of Appeal requesting for dates on the above matters. We also continue to follow up with the Court of Appeal to receive pending orders for Cytonn Investment Partner 16, which is Kilimani, and also for the issuance of new dates.
So we proceed. Thank you, Celestine, for that. We proceed to the legal update from KDH. Unfortunately, I do not have the slide now, but he's able to do it orally. So I welcome Stephen to proceed. I'll be able to share this, the presentation later with the creditors.
Good afternoon, good morning, or good morning. I apologize that my slides are not visible for you to see what I had to say, but my update is quite similar to what Ms. Koila has just updated. My part, there's one application that has been filed on behalf of the Creditors Restructuring Committee at the High Court, which application is just seeking similar things as have been asked by Ms. Koila in her other applications. In that one, the Creditors Restructuring Committee is seeking, first of all, to be recognized by the court in terms of the capacity as creditors of Cytonn. Secondly, they are seeking to stay the decision of the court to liquidate Cytonn and the assets which Cytonn holds. Another prayer is that they're seeking to have a vote called on the question of the debt settlement program proposal, so that that is considered by all the creditors in a manner that allows them to vote on it and decide if that is the route that they want to go. And the fourth one is that they would like the appointment of a new insolvency practitioner to handle whatever route the court decides that we should go with regards to Cytonn, which is similar to what Coyle has also mentioned in one of our other applications. So that's what we are seeking. The challenge there has been that the court has taken quite some time to set it down for hearing or to give us directions on when that application will be heard, how it will be heard, and make a decision on it. So that application is still pending before the High Court. It is in a similar state of limbo as the other applications because of the recusal application that had been filed against the judge, the sitting judge in that matter. So, and the recusal application makes everything stop. Until that is decided, everything else is put in on hold. That is the High Court. So we will give a similar update on 28th June when the court give directions on the recusal application and also the hearing of the rest of the applications. For the Court of Appeal, we have only two matters at the Court of Appeal in terms of the CRC. The first one is a substantive appeal on the actual ruling of the court on 30th November 2023. The second one is an application seeking to stay the ruling of the court on 30th November 2023. Again, as Ms. Coyle has mentioned, the court has given certain stay orders, which were also given in the file that was the application that was filed by the CRC. So we are really on the same boat. It is just that some of the matters are pushed by Ms. Coyle and the Mali team, but in terms of just the creditors alone, then again, it is a different presentation just for the purposes of separating those interests in terms of how the court sees those different players. So that is really the update. You'll get more information on 28th June in terms on what the court decides in terms of recusal. And once the Court of Appeal gives us directions on the hearing of our application, which presumably will be on the same date as the ones filed by Ms. Coyle, then you'll also get an update on that.
Thank you very much, Stephen. Now we proceed to CRC updates, and I would like to invite the legal representatives or through the chair. May I welcome Leshan Anton to give us few updates, then the chair will top up on the same, then we proceed to other items. Welcome.
Thank you for that. So the CRC, basically investors or creditors like unsecured creditors like yourselves, our concern really has been how can we get money back into the pockets of creditors as soon as possible. Now, there are two things that are stopping money from flowing back into our pockets as creditors and investors. One, there is a preservation order that was issued by the High Court in January 2023 that stops Cytonn from selling anything. Okay, so Cytonn can't sell and give you money back. Okay, and then there's stay orders issued by the Court of Appeal in December 2023 that stopped the official receiver from selling anything, at least in the interim. So the official receiver can't also sell and give you money back. So those are the two things that are standing in the way of us getting money. So what is the CRC doing? Because we want timely resolution of, we want this money in our pockets. The CRC, we've been trying to have these cases resolved out of court. Okay, so we've engaged a number of stakeholders involved. One, we've engaged the creditors committee that is leading the liquidation team. Okay, we've engaged them in writing, on phone calls from December 2023 until last month, May. Okay, we've engaged the official receiver, and we've had a meeting with the official receiver as the CRC. We had a meeting with them on 13th of March 2024. Minutes were shared. Minutes of the meeting were shared to creditors by email. If anyone doesn't have the minutes, I'm sure they can be shared. Just share your email address. They'll be forwarded to you once again for you to have a look at the deliberations at the official receiver's office. We did not, the official receiver was not willing at that meeting and has not been willing to engage out of court in resolving this matter. So what did we do? We approached the Honorable Attorney General of the Republic of Kenya, 23rd of April, 2023, we wrote to him. We've sought a meeting with him. He has sought some information from the official receiver. The official receiver's office is sort of a department under the state law office, which the Attorney General heads. So we've sought his intervention. He's not yet written back to us himself, but we've been following up on that as we try to resolve. The other people we're engaging, we've engaged, of course, SBM Bank with a view to having them. SBM Bank are involved particularly in Alma, just one of the assets. SBM Bank are involved in the Alma. They're open to discussing, but you know, these discussions can't happen without the official receiver, who themselves have not been willing to engage. Okay. The other parties who are also involved in this matter that we need to engage, creditors like yourselves, and that's why we are having this discussion with you to update you, because we need to hear from you as well. Cytonn, the Cytonn team, because they're the debtors, they're the people, the entities owe money. We've been engaging them quite extensively for quite a number of months now. Contractors, some of whom are owed money, okay, a part of that discussion as well. The whole idea is this, before we can get the money back into the pockets of creditors, we need to resolve these court cases, and we're trying. They're taking quite a bit of time. You've seen from the list that has just been shared, Court of Appeal alone, about 9 to 12 different applications and appeals are being filed there. High Court, quite a number of them are also pending, including an application seeking to ask the judge to step aside from this matter. So it's going to take quite a bit of time, and we're looking for the most efficient way of having this matter resolved, which in our view is through out-of-court discussions or negotiations. And these are perfectly allowable under our laws and our procedures. We'll still try to do that. We are being thwarted, unfortunately, in that endeavor, but we steer the course. The second thing we want to do is value, okay? As much money as possible back into our pockets. And what that sometimes requires is increasing the value of the debtor's assets. So if we say, for instance, Alma, which is just 3 blocks away from being completed, the rest are already inhabited, okay? We are saying, listen, if you sell as it is, you make so much money. But if you complete them and sell, then you make even much more money. You're able to get more money to pay us as investors. Why don't we do that? How long will it take? 3 to 6 months to complete. Why are we not doing that? We then try and meet the official receiver, try and have a conversation around that. They don't want to have a conversation around that. Try and engage the creditors committee that is leading the liquidation team. They don't seem to want to have a conversation around that. We are encountering hurdles, but we must keep on. And that's why we're engaging you as well as unsecured creditors to have the information that we have in your hands and to have your views as well and your buy-in so that we all move together to resolve these matters timely. Is got to increase the value of the assets and get back as much money as possible. If you look at Kilimani land, for instance, the value, according to the Cytonn real estate team, from the slides that you have, is about 1.7 billion. That one can be easily solved without much problems if we get these preservation orders and stay orders out of the way. 1.7 billion resolves about 17% of the debt. Okay, and that can happen fairly quickly. So add the shares in Superior Homes, that you're already in the 20% and above region of the money back. Okay. Alma, which can be fairly completed in a fairly short period of time, you add that into the equation, you're getting back quite a bit of your money back as soon as possible. The concern a lot of our members have had is when they look at the presentation and see that it might take 6 to 8 years to complete some of these other projects. But how we are looking at it is, what about the ones that we can resolve fairly quickly? How much back of our money will we, what proportion of our money can we get back fairly quickly? And if you do the math, you end up in the region of about 30 to 40% fairly quickly, as you wait for these other projects to complete. And those other projects that will take a bit of time to complete, they are pre-sales. Okay. So that even as the project is ongoing, I think there's quite a bit of cash flow that can be coming in. So we have a way forward. We are trying our best. It's not been fairly easy, but we are still staying the course. With your support as creditors to this process, we should be able to make quite a bit of progress. We encourage all of us to please avoid, we have been fighting each other for quite a bit of time, and that is slowing down the process. It is time now that we speak together. People who have classified themselves as pro-restructuring, others who have classified themselves as liquidation team, we all want the same thing, which is money back in our pockets. Can we at least have a conversation? Sit down together, see what we can agree on, and start working on that, executing. What we can't agree on, isolate it and find solutions. That way we move together in a manner that ensures there's money back in our pockets as soon as possible. I beg to stop there, Mr. Chair.
Thank you. Thank you, Leshika, for that. Now, welcome Chair to give a top up on that.
Thank you very much, Tim, Pamesa, and the panel here. And I want to say good afternoon, my fellow investors. I think this meeting should be a wake-up call for all of us, because we find ourselves in a very tight corner. We are unsecured creditors, and there's no doubt about that. And if we go through liquidation, we will be at the mercy of the liquidator, who is the OR. If we go through restructuring, we shall be part of the process, we shall control the process, and we shall get a good return, projected to be 100% of our investment. You have heard what we have done so far since we came into office, barely a year. As we stated in our last meeting, the CRC team went through and inspected the projects, the assets purchased by our investment, one by one. And upon our visit and looking at the DSP, we were convinced beyond any reasonable doubt that this is the way to go, restructuring, and through that we shall be able to recover our money. Unfortunately, that has not been forthcoming, as has been highlighted by Anthony, because of the many legal cases, both in High Court and Court of Appeal. We have also done diplomacy talks with the officers, government officers, and our colleagues in the CRC team, as has been alluded by Anthony. All that has not borne any fruits. And therefore, the only option we are left with is to go through the court. I want to mention here and now that the court, we have a right to go to court just as any other creditor, whether secured or unsecured, can go to court. And the court will definitely listen to us. We have already filed application in the High Court representing all the creditors, both unsecured and more specifically unsecured. We have also filed applications in the Court of Appeal so that we are heard, our voices are heard. Unfortunately, in the initial court cases, I think many of us were not up to speed with the affairs of our situation. And therefore, it took us time for us to realize where we are heading to realize, oh, we are going to lose our investment. What can we do? And therefore, when people realized that, they came together and set up the CRC team. This is the Credit Restructuring Committee. And I've already highlighted what the CRC team did when they came to office. I think the only option now left for us, having hit a hard rock with the OR, having hit a hard rock with these other parties, we are waiting for communication from the AG, which can be positive or negative to us. But the ultimate solution now is two. One, through the court. Two, through the creditors themselves. Under Insolvency Act, we have been advised, and we believe so, that we are as strong as ever to fight for the recovery of our assets. The court can hear us, the court recognizes our strength, and we should not just keep quiet and let that opportunity get out of our hands. We will continue fighting for all of us until we ensure that everybody gets 100% return on their investment. It might take time because of the court processes, which we don't have control over, but at the end of the day, we shall be there. Thank you, and all I need to ask you is please support this team. Support this team because we have been called names that we are Cytonn, we are this and that, but I can tell you we are unsecured creditors and we represent you. Cytonn is a body through which we invested, and having heard what they have for us, and having been convinced, and having been accommodated, we've joined hands with them because they also have a stake in the investments, like you have heard, so that we go and fight. We cannot sit down and fight, watch our investments go down the drains. Gentlemen, let us wake up and let us just reason and put aside emotions. And that way we will emerge. I want to close by asking everybody, please have confidence with this team. I am sure we are going to win this battle. Thank you.
Thank you very much for that updates. We are almost entering into the question and answer, so I can see some few questions coming in from the team joining Fajori. That is very okay. Kindly keep them coming. I am now pleased to give an opportunity to any other member of the CRC team, ranging from members to the communication lead, also the vice chair, to give their comments before we proceed to question and answer. So keep the questions coming. If you feel you can do it orally, in the few minutes, I'm going to allow anybody who wants to speak to raise up the hand, then I'll unmute you, then you give your comment. Those who can do through the chat box, thank you for doing that. I can see we have already a couple of questions. We shall tackle them in a few minutes. So I welcome another member to give a comment. So I'll start with probably Bernard here.
Right. Grateful everyone for your time, both online and physically here. Everything that have been said is quite in order, and as part of the CRC, my one line of encouragement is this, that when we all come together on the table and have a way that is going to reduce the long process of the litigations, and then have these agreements in form of a consent agreement that is signed by all parties, such that the same is sanctioned by the court, and then the creditors, mark the word, the creditors, own the assets and also own the process of the sales and the money coming in and the distribution, then that will be the way out. As it is now, we are at a stalemate. We've had court orders stopping ORC from proceeding to do anything else other than meetings, yes, but you've not seen the fruits of the same, and it has been years. You are also aware now that also there is court order stopping Cytonn itself, where we invested, from also proceeding forth with any sales, and start distributing. But I know as creditors and fellow creditors that are listening, we are so much eager to have at least some kind of goodwill to see that some assets are sold and some distributions are taking place. With those two orders stopping those two entities from proceeding to do anything, that is the stalemate. So CRC reached out, as you've heard, but there seems to be some hardening positions for reasons that probably are not so clear to each and every one of us. So how do we make all those reasons to be clear to each and every one of us? Is all creditors to pull together and listen to everyone and see the reasoning, and we get enlightened and then come up with agreement. And that agreement signed and sanctioned by court as the legitimate process, so that everyone is involved and everyone has the same interest, sell and distribute, but there are litigations and counter litigations. Thank you, and God bless you.
Thank you, Bernard. Vara.
Thank you, Mesa. I do not have anything more to add to what has already been discussed. You've heard the legal updates from Cytonn. You've heard the legal updates from the CRC, whom I represent. I'm a CRC member and also an investor like you. The reason why we were pursuing a parallel legal avenue was because we realized that the justice system is highly bureaucratic and it's very slow. So we said, why don't we get together and pursue a different parallel legal avenue so that we can, come to a conclusion much faster than the other one. However, I want to tell you that recently we realized, we came to the awareness that it is actually even more difficult than the other process. And that is because, the key word here is transparency. I want to be as transparent as possible. There are a few members in the liquidation process that is actually working against us. That's the truth. And they are actually frustrating our efforts. So what I would say is that if, please don't engage yourself in any negative propaganda or any sort of, don't be swayed by your emotions. Let's work with the facts or anything, and particularly don't engage yourself with any negative propaganda. We mean well when we do whatever we are doing here. We want our money back, you want your money back, and we mean well. We want to be as transparent as possible. So talking about transparency, I also want to say that it's going to be a very, very long process. It's not going to be rosy. So we're doing everything we can, and we'll keep you updated. That's all we can say and do. So thank you.
Okay, thank you very much for that. We give this opportunity to the Vice Chair, that is Ephraim Karangi, to give his comments.
Thank you, everyone. My simple comment is that the reason why I join or I support restructuring is because of the promise in the return of my investment. That is 100%. And I don't see anything else that is profitable from the side of liquidation. And therefore, I'm ready to wait that short time or that period until we can be able to get the full say of our investment. Because what is making us the legitimate voice as we stand is that we all invested, we all came with the money to Cytonn, and that money, we did not give it out. We invested, having hope that one day the money and the interest will come back, and nobody can make me stand out of that way. Therefore, I have decided by my own self that I will go the restructuring way because I have understood it. It is transparent. I'm well informed about it. Whenever I have the question, even while I am at home, I have somebody to ring to, and somebody would listen to me. And even SMSing and asking for a question, there's somebody that I can refer to. But in the process of liquidation, nobody is there to directly communicate or even to give the information on what is transpiring or that which is going to transpire. That makes me believe that restructuring is the best way. I fully support the statement given by our chairman. And as a team, if we combine forces together with you as investors, we are going to win the battle. Because what is required here, or the principal factor here, is that we all be confident that one day we shall get hold of this thing, and we shall be allowed to have the say in our investment. Allow me to give me a short illustration from the Bible in the book of Samuel, first chapter, where King David got threatening from the Philistines for 40 years. At the 40th day, there emerged a lad, a small boy, who was not experienced, would not be able to put on the armor that was required to fight. The boy came and had the threatening from the side of the Philistines. And he went to the king, Saul, and asked him, what will be given to him who will kill the Philistine Goliath, who was always threatening the Israelite army? The king gave a promise, and the lad got confidence. He tried the armor that could not fight him. And the lad went and faced faced Goliath with the armory that he was acquainted to, the sling and 5 stones. He faced the Philistine, challenged the Philistine, and knocked the Philistine with only one throw of 1 stone, and the Philistine fell down with a great thud. And all the Israelites were happy and in jubilation over what happened. It took time. 40 days was not a simple time for the king waiting for 1 day for victory. So it will take us also time. And as the Philistine fell down, David took the sword of the Philistine, cut the head, and carried the head to the king for witness that he has killed the giant. And therefore, finally, the Israelites won. Dear investors like myself, let us all join hands together, and we are soon going to win the battle. Our togetherness matters most. Once we join together, our hands are strong, our voices are strong. Imagine with our investment in togetherness, we can challenge anything and we shall win it. So be strong, like myself. Thank you.
Okay, thank you, Tim. Thank you very much for that update. I can see we have quite some questions and some compliments. Others are not really questions, but I'll share all of them here so that we can be able to respond. But before I do that, if there is any member who has a comment or feels there is something to do, to comment or to add, you are free. The next 1 minute, so I'm going to share the questions. So if we do not have any person from this team here, I now proceed to people online. Now this is the forum where you can ask your questions, and also you can seek clarification and part where you did not clearly get the discussion. Here is the time when you can be given a response or clarity on any matter regarding what we have been discussing. So I proceed to have a question from one person one creditor who has raised up their hand. That is Trisha. Kindly, you are now ready to go. You can unmute yourself, then you proceed with your question.
Oh, hello, everyone. So I just wanted to ask, okay, if I agree to the restructuring plan, am I sure I'm going to get my money? Because it seems like there are some stubborn people who don't want to engage.
Okay, I give this opportunity to Leshan to respond.
Thank you, Trish, for that question. I think first is to address the concept. What is the distinction between restructuring and liquidation? Okay. Once we understand that the difference in those two concepts, it's very easy for you to make that decision. So
no, I've agreed to the restructuring plan, but my question is, if the stubborn investors continue with their stance, is it going to affect my position?
No. I mean, if they don't change their position, if they don't decide to engage with us, it doesn't affect you at all, because we are taking a number of ways to ensure that the position is sustained. We've tried, and we are still on the diplomacy front, out of court settlement, but we are also in the courts as well as CRC. So we are using those two options. At some point, I'm sure we'll be able to succeed. It doesn't affect the value of your investment, because the assets, this is real estate, it's not dissipating. The assets are still there. So what we are trying to do in the courts is actually safeguard the value of the assets. We want to stop anyone from selling them at forced sale value. We want to be able to sell them at an enhanced value at market price. That guarantees your principal. At the very, that's, and we have investment analysts here seated at this table. In our CRC, we have people from finance backgrounds here to help us with that. So the only way we safeguard your position financially is to make sure these properties are sold at an enhanced value. Okay, so we enhance the value and then we sell them at market value. You have control over the selling process.
Okay, the other question is, obviously, Cytonn's name has really been tarnished in the media. How confident are you that once the projects are finished, people will buy from you?
I see. So there are a number of, for instance, the Kilimani land, that already has people interested in buying, regardless of, there are people already. And you are the official receiver's office, they confirmed as much to us also. The shares in Superior Homes, there are people ready. The question is, are they being sold at market value? That is our concern on behalf of creditors.
Okay.
Tricia, I can also join in there and say that this restructuring actually plays the role of a defender in a football match. We are the people depending our assets, because some people wants or wishes them to be bought, to be sold at a throwaway price. We are defending that, and we are saying our assets should not be thrown away; they should be sold and at a market price, and we get back our investment. That is what we are doing. And I think, yes, we will get, not you alone, even me, we shall get our money back. Now, the issue of Cytonn coming in, interested investors outside there, for example, people who want to buy Kilimani plots or Superior Homes shares, they are not being asked to buy Cytonn. They are being asked to buy properties for them to invest.
Okay, they are serious investors. So
yes, serious investors will buy the properties because they are good.
Okay,
and I can stand here and tell you all the properties we have visited are all marketable and they are in good places.
Okay.
Okay, thank you, Tricia, for that question. I think those are also the questions you had asked, you had chatted. Yeah, so I feel you have been given a response, an appropriate one.
Okay.
Okay, thank you. So I'll proceed to other questions from other members. So there is one from Dennis Karanja. That is, with the 6 to 8 years project completion time, forfeiture of interest, etc., we are not looking at 100% money back. That is like 7% principal amount. Any comment, Victor?
Thank you, Dennis. And thank you for your question. I think this you are asking in the context of where we are, in the circumstances we are in, Dennis and other creditors. We want to look at what you will get, your principal, your very principal. Forgive me if we want to not factor in the term value of money. But having said that, the equity component of the restructuring will enable you to tap into the upside in the event we get it in the assets. And as Leshan has mentioned, this is real estate, and we know the time it will appreciate. So one of the reasons why we are saying we convert part of it into equity is that in the event of an upside, then you are going to get that that is commensurate with your equity component of it.
Thank you. Thank you very much. There is another question from Mungai, from Samuel Mungai. Yeah, Karen, I'm seeing your hand. I'll give you an opportunity to speak. So this question from Samuel Mungai is, have you considered approaching His Excellency the President William Samoei Ruto for buyout, as he is capable of delivering as a private buyout investor?
Thank you for that suggestion. We have not approached His Excellency the President, but there is no door that we are unwilling to knock in pursuit of the interests of creditors. There's no door in this country that we are afraid of knocking. So if the time comes and we have no other option, we will pay State House a visit.
And so are the other offices. If these properties are put up for sale, and anybody willing buyer, willing seller is welcome. And whether they come in person or through process, they are welcome. Our bottom line is the return of our money. Thank you.
All right, thank you. One more question before I give Karen an opportunity. So there is from Constance Sarah Oya. We are together with you. Thank you very much. Samuel Mungai, I was to get 18% after 1 year. It has been 4 years, and all there is to show for it is delays after delays after delays. I am tired. That is another comment, probably.
I think Ibrahim can answer that.
It's good to have confidence, and also consider that time has brought out by the two sides pulling together. Some seeing as though they are most successful than others, and others thinking that they are better than others. But a short time is going to be a determination of us winning the restructuring team, so that we can halfway, and we shall exactly do as it was explained by Reshani, and we shall be able to see the return of our investment. Thank you.
And again, I want to encourage you not to give up.
Yes.
We should not give up. Giving up is giving victory to the people who want our properties. Thank you.
All right, thank you. Now I proceed to give Karen an opportunity to speak. Karen, you can proceed. You can unmute yourself.
Thank you, all the colleagues in the room and all the investors. So mine is a scenario of whether there has been built a scenario in which when there is a stalemate, then what happens? Because we have been at this conversation, if you ask me, for the past 1 year now. The same presentation has been made over and over. So what is the way forward in the situation where there is a stalemate on both ends, where there are some of us who are not willing to liquidate, there are some of us who are agreeing with the restructuring plan? What is there? Because for what I'm seeing, there's a lot of litigation even coming from Cytonn, which of course continues to, either they're buying time or it continues also to delay the process. I'm also sure the lawyers are not coming in cheap. So that is also costs that are being incurred by the company. So what is the scenario that has been built in the case where there is this stalemate? Considering that you also have investors who are senior citizens who put money that is in their pension, are they going to their grave without never knowing what became of this? So it's good to have hope and all that, but what is the scenario? Hope is not a strategy. So what is the scenario that has been built in case there is a stalemate in this going forward? I would like to hear that beyond the regular presentation that you've made for the past 1 year plus.
Thank you for the question. Anthony Weshani, you can respond.
Thank you. Sorry, I didn't get the name. Karen, those are very good questions. Karen, the statement is there. So what is the way forward? One, you want to have information, accurate information in the hands of creditors as much as possible. And that is why I think for the very first time, you're getting regular updates from the CRC. There was a detailed minutes of the meeting that was shared around. And if you didn't get a copy, you just put your email up on the chat, you'll get a copy, all right? Secondly, when there's a stalemate, what do? We are having a hybrid, we're adopting a hybrid solution to try and unlock the stalemate, okay? So there's the court process that is going on, and we are trying as much as possible to push for resolution of the court case as soon as possible. Two, out of court discussions, okay, with all involved stakeholders, which is why we're having this conversation with you and you as our fellow unsecured creditor, which is why we're engaging the official receiver, the attorney general, secured creditors, the banks, okay, contractors who are owed money. Most of these people are willing to meet except the key party. And the key party is here, the official receiver, okay, and our fellow creditors, the creditors committee, okay. So we are trying our best. Those who are unwilling to meet, we have no option but to try and get them out of the process. The official receiver has not been willing to meet. We have an application in court. We are saying, listen, we want to have a meeting as creditors. If you are not able to meet us and discuss with us, please let us get another person as an insolvency practitioner to take over the process. Okay. We're also considering other options because if they're going to be a hurdle, they're not helping us. Official receiver is there to help us as creditors get our money back. But if even granting us a meeting is a problem, then they're part of the problem, not the solution. And they need to get out of the process. So we're exploring these options. Like I said, it's a hybrid where we're trying to talk to people and agree. But at the same time, if we don't get resolution there's the court process that is going on parallel. Help us for the creditors. So unfortunately, it's been a painstaking process, but I'm sure at some point we'll conclude the matter.
Okay, thank you.
I think just to also add on what Anthony has just said, other than voting to either remove the official receiver or to have them remain in office, we've also through our application in court sought that there be a meeting of the creditors so that you put this debt settlement proposal to a vote. So there you'll have a chance together with all the other creditors to then say in what you want going forward. So at that point, then I'm sure that the CRC will work together with the creditors to make sure that if that meeting is granted, then everyone is called to come and have a say to what they want for their investments.
Yeah, maybe to add on that and just to make a point is that as CRC, we are very grateful and thankful to all those who have supported the DSP because you have given us muscles and space. That's why we are standing very firm, very confident that behind us, we have very many unsecured creditors who are supporting us. And even as we front going forward, we are going as a team. That confidence is what is driving us. And again, also the legal backing the legal backing. We have space in law as unsecured creditors to be heard by the court. The same court, the very same court, who have given the OHAR the mandate to go on. And therefore, that opportunity, we have to seize it. Unfortunately, nothing good comes for free. It's going to be expensive, and that's why we have lawyers. The other side, they also have lawyers. The other parties, they also have lawyers. And without lawyers, we may not go far. And these lawyers did not just come by themselves. We requested them, we invited them, we contracted them so that they can support us in this fight. And therefore, please be confident that we know where we are, what we are doing, we know where we are going, and we know how to go to reach there. Thank you.
All right, thank you very much. Karen, I think you have been answered. Okay, we proceed to the next set of questions. So there is Jonathan Quill. Seems common sense to go with restructuring so as to complete projects like the Alma and the other sites. Opting for liquidation will only result in small return of your money. Good marketing will assist with the sales with a bit of pressure on the Cytonn team. That is okay, thank you. That was not a question. Another one from Mongai Kamau. Thank you, team, for the detailed updates. I want to inquire about the fate of the buyers who had signed agreements and paid in full at Arima. Are they considered as unsecured creditors, yet they are purchasers for the value? Maleric?
Thank you, Mongai. So we have first, I would like to inform you, and I think you are also part of the litigation, where the homeowners were trying to make their case before Honorable Mabea, in the case of Alma. In the case of Alma, so they joined hands and put in an application under Mali Advocates, since one thing we agree is that when Honorable Mabea was making his first ruling, it was not in his knowledge that we had these properties he had preserved. We had people who had bought the properties off plan, and others had already even taken possession, just awaiting their titles. So it was just a good move to make the information known to them, and he has never pronounced himself on that. But our legal team is here in terms of the ranking of if they be secured or unsecured on that. Maybe I'll leave that to our legal team, that in case of a liquidation scenario, where will the homeowners rank, given that whatever the vehicles that were under liquidation are CHIS and CPM. So maybe Celestine can assist on that.
In terms of the fate of the home buyers, where you have paid in full, what we have gathered from SBM Bank is that they would be confirming the amounts were received. And then if the amounts were indeed received, because now the secured creditors with priority rights of Alma, then you would not be considered unsecured creditors, but would still be in possession of your title deed. Sorry, possession of your units. We know that part of the reason why the process was stalled and homeowners were not able to get their titles was because of the preservation orders. But before anything happens, then there has to be a full audit to confirm the amounts paid, so that no person is discriminated in the process.
Right. Okay.
Thank you. On to the next question. Okay, we proceed to Amolo Okero. Yes, agree with other above. I too support you. Keep fighting for us, please.
Thank you.
Thank you very much. Another one from Jonathan Quill. The lady talking is right. I think this is the time Valentine was speaking. The lady talking is right. The slow speed of this process has been crafted by a handful of individuals, not the majority of us who has had and money stuck in this situation.
True.
Yeah, thank you. Another one from Mongai Kamau. Well spoken, Chair. We are behind you as one voice. We are strong and more effective.
Asante.
Samuel Mungai, how much is the Kilimani land worth as at current market value?
Victor.
Victor, you can
It is 1.6 B.
1.6, 1.7?
1.69. So 1.6, 1.7 B.
Thank you. Then another one from Mungai is CRJE on the ground at the ridge?
Who are those?
Derek.
I don't understand what CRC is.
That is the contractor at the ridge. We still have the data, as I mentioned, part of the people who are interested parties in this. So they're still on site. They're not constructing, but they're still there.
Okay, thank you, Vivian. If thank you, Samuel Mugai. If we have not responded to your questions properly, just raise up your hand. I'll be able to unmute you so you clarify. And to the next question, Vivian Wekesa, there is a caveat posting about Superior Homes shares by Dande. Can you clarify about that, Adams?
Thank you, Vivian, for that question. First of all, as the main purpose of restructuring is to make sure that you get the maximum amount of your investment. As you, the main purpose where that caveat was posted was that there is an interested buyer, an internal interested buyer from SHK who wanted to buy that property at around 200 million, and that property is more than that amount. He has already approached the official receiver that he wants to purchase purchase the shares. But if you see, once they purchase that shares at 200 million, it means that the investment and the money which you are not likely to get the full amount, because that amount is going to be divided amongst the secured creditors first, then they'll come back to you and unsecured creditors. So we thought it wise to put a caveat there because, first of all, we have a stay order on Superior Homes Kenya. No assets, no shares need. We have an interim stay order from the Court of Appeal. That's them selling that property. They will act against the court orders. So the main purpose why that caveat was posted is to just notify any public member that indeed that share is not for sale for now, as we have a stay order, and that amount which they are trying to sell that share is a bit questionable.
Yes. Thank you, Mali. And for this, and you heard what the lawyer is saying. There's already a buyer who has approached the OHA to buy the shares at 200 million. In our projections and estimation, the shares are worth 800 million. So you can see the shortfall, the cut between 800 million and the 200 million. That is why we are fighting. That is why we are not sleeping, so that our investment is not just thrown away. If we leave it to people outside there who have no idea how much investors suffered, I think we will have ourselves to blame. This is a very clear indication of what we have been saying. The shares are worth 800 million in our projections, and they are being sold at 200 million. What about that, guys?
And maybe to add to what the chair stated, you have to note that also the offshore receiver has interest in all these assets. There's a cut which the offshore receiver is getting. So any buyer who approaches the official receiver that he has cash and is willing to buy the assets or the property, the official receiver will welcome that buyer with open arms without even your consideration at hand. That's why it's better you as the investor to take part in all this process. Thank you.
Okay, thank you. On to the next. We have lost faith. That's from EK and 3 others. We have lost faith and confidence in Edwin and his team, period. Most investors, including me, find it difficult working with this cohort. Maybe, Lashan, you can shed light on that.
Yeah, EK, we are investors just like yourselves. The distinction between our team and the other team is we don't want to personalize the issue.
Come down.
Okay, there's no point personalizing the issue. The simple issue that we are dealing with is what is the value of these assets as they are now? How much do we get if we sell them as is? How much do we get if we enhance value and then sell them? Those are the three issues. It doesn't matter who is, the personalities involved. Every one of us has been without their money for, I think Trish mentioned 2 years. I think for me, it's actually 4 years since 20. I don't think anyone has gotten a cent back since 2020. Okay. So we can choose to focus on personalities and start, that campaign, name calling and whatnot. And, it's not just Edwin who's been called names. I think everybody involved in this process has been called names. Even the chairman. Even the chairman, even myself. Okay. So I want to encourage you, EK. Let us take our focus from personalities and focus on issues, on the assets. And ask ourselves, what do we get if we sell this property as is? Vis-a-vis, what do we get if we enhance value and sell? And what is the priority of the money flowing? If we sell Alma today as is, the first person to get the money is SBM Bank. Okay? They get their entire money back first, their loan plus interest. Whatever remains, okay, the other people claiming, the contractor who's built is claiming quite a bit of money there. So they get paid. Okay, so what is left for you and me? That's the question we should be grappling with, as opposed to looking at personalities. Where we are seated today, this is Cytonn. If it is sold today, the first person to be paid is KCB Bank. Okay. Once their loan and their interest on the loan is paid, whatever remains is now to be distributed amongst us. So the question we ask ourselves is, will it be sufficient to cater for our investments that we put in? Or should we enhance the value of this place first and sell so that the cake is bigger for all of us? Mm-hmm. Let us focus let us shift our focus. I think, and I'm sorry to say this, the creditors committee has been focusing too much on personalities. We want to shift the focus to the assets, value enhancement, and timely payment of money back to people.
Yes, and I think I want also to support and add on that. We are not dealing with Edwin and the team here. We are dealing with the assets bought by our investment, which we want to take back. And you have just had a very good illustration that one of the assets bought with our investment is Superior Homes, whose current value is estimated to be 800 million. And it is being sold at 200 million. How does Edwin and the team come in there now? In fact, by them putting a caveat, they are safeguarding your interests. They are safeguarding our interests. So, please, let us look at the assets and just appreciate that this team here is seeing beyond. They're seeing beyond that and with a sole objective of recovering our money. Asante.
And maybe just to add on what Chair stated that, and what Anthony has stated, at the end of the day, it's not about Edwin or Cytonn, it's about you as the investor getting your money back. As a good example is the Superior Homes Kenya. Once they sell that property at 200 million, ask yourself, am I going to get back my money? So in as much that people want their money immediately, but at what value do you want your money back? Because first of all, you have to categorize the three creditors: the secured creditors, the unsecured creditors, and those who owe, like the contractors. Also, they need their money back. So we need to shift this argument from me getting back my money, the best value of my money, the one which I invested, instead of abusing. And in fact, Edwin putting that caveat has really helped. Yes. Compared to him not putting the caveat. True. Because by now, we wouldn't have known that indeed the supplier wants to buy that property at 200 million, something which the official receiver is not communicating to the investors. So We are open, the CRC is open in each and every dealings, and anything that comes out, CRC is up to date. Compared to the official receiver, we don't know what he's doing, and we don't know whom he's talking to behind the scenes. That's what I can say for now.
All right. Okay.
And just to add on as well, is that to my fellow creditors, it is obvious that if we put in a lot of negative energy, then we even hurt ourselves more than the person that we think we could be fighting personality wars and character assassination. So the question is, where do we want to direct our energy? Of course, we are all hurt. There is no dispute about that, because we are not getting returns as we would have ought to have. But now, what is the best way forward? Is it personality attacks? Is it character assassinations? Edwin as an individual and Edwin as an institution that is called Cytonn, we need him and we need Cytonn in this process. Either way, liquidation or reconstruction. The court process needs still these two persons, both the natural Edwin and the legal Edwin, in terms of Cytonn as the head of it, because also of providing even the records, the data, the information, you know. So had we learned about that much earlier, we probably couldn't be even where we are right now. And as we go through this process, remember, for anything to move forward and probably move forward faster and move forward positively, everybody it should be required on the table. And that's the direction that the CRC is championing. Everybody has to be included at the table. And if we as creditors think we shouldn't even have Edwin see him, you know, then we are lying to ourselves. Those hard questions that we need answers will require him to be present, will require Cytonn to be present and answer those hard questions. And every process of all this, you know, requires them to be there. So let us focus. Let us not have negative energies redirected inappropriately for character assassination. The CRC itself, through even chair as an individual, our legal counsel, Anthony, as an individual, have been personally attacked in so many ways, including some other CRC members that are also not here. But we soldier on. So let us be sober for any good outcome and even a quicker outcome out of this. Thank you.
All right. Thank you very much. I now proceed to, I'll give EK. The question we were discussing was from EK. He has raised up his hand. Let me unmute him. Then you quickly ask your question. Then we proceed. He has already dropped his hand. Okay. I think you have dropped your hand. I assume that, okay, your hand is up again. All right, just go on. You can unmute yourself.
Thank you. Thank you so much. Afternoon, everyone. I was trying to unmute. Can you hear me?
Yes, we are.
No, thank you so much for the many words, and I mean, where I'm coming from is just to respond to what you have said, which I must admit all makes sense and it's very logical. Personally, I mean, the DSP in theory makes sense. I mean, I'll still get my money, and trust me, if the DSP works, I'll still walk away a happy man. The other team, I mean, you said rightfully that there's a lot of name calling. I mean, I'm not all about that. I'm just about my point of view that for the DSP to work, you guys alluded that Cytonn still has to be there. And where I stand is, I can be part of the DSP, but my point of view is we cannot continue with, let me not even call him Edwin, but the whole team, because their character has been tainted, not because of name calling, but I mean, their track record and getting us here in the first place. There's a lot of deception that has gone on. I cannot even articulate enough the chain of events that has happened to get us here. I will not go back to that. And I'm not all about name calling. So all I'm saying is, maybe you guys, what you can do differently this time to win the hearts of the guys who are not converted, and I'm not one of them, I'm not converted, but if there's a way that this can go on without the team led by Edwin, I know the CRC will be there. You guys will be there. You're going to be a watchdog, or just our eyes, or that's the proposal. But I firmly believe that we will not get a lot of traction with the team that is spearheading the DSP. That's my humble submission.
Well noted. Thank you.
Thank you.
Thank you, EK, for that submission. We proceed to another question from William Aka. His question is whether we have faith in him or his team does not matter. In my opinion, at this point and time, we need to be objective about the two options presented before us. I'd rather wait more time to get 100% of my capital than get only 14%. I will decide my feelings for the team after having money in my pocket.
Well noted. Thank you.
So thank you for that, William. Then William Maina, please send minutes presentation to williamc.maina@gmail. We'll do that. Suggest they may, okay, all those who are requesting to be sent the minutes that Anthony mentioned, we shall do that. I proceed to James. That's for the great work and in-depth look and preview of all aspects. I think a strategy to engage more creditors is needed beyond the meetings, and that point on the vote could be one. Perhaps a petition or something officially convened and accepted by the court. Experts on mediation could help craft something.
Thank you. We are on course.
All right. Then we have James Kaviru. What is required for the restructuring process to commence? Ashan?
Yeah, what is required is first resolving the court cases, okay? And we are trying to resolve that by way of what we've been proposing since September last year is resolving these cases by way of a consent agreement where all the parties who are in the court process come to the table, we seek out areas of agreement, we set out areas of disagreement and come up with a solution, which is set out in a consent agreement. Filed in court, once it's filed in court and the parties confirm that's the agreement, it becomes an order of the court. So, for instance, the consent agreement can say we agree to sell Kilimani land for X amount of money, okay? So, at a minimum of X amount of money, the valuation, current valuation, that money will be applied this way, okay? It can be the proposal that has been floated by the Cytonn team. 50% of it is distributed to all creditors immediately. The 50% remaining finishes ALMA, which will take a few months. After that, Superior Homes shares is sold, it's applied this way. So that's the way for us to get to the restructuring, we have to resolve the court cases. We are trying the hybrid method. Hopefully we'll soon conclude and then embark on that. Yes.
Thank you. And to the next question from Evans Olo. Thanks for the information. Actually, I wanted to ask about the legal position. Beyond a desire for mutual agreement, does the law support unsecured creditors? Can you force a legal binding secured creditor to abide by the wishes of unsecured creditors? Purely from a legal standpoint, my understanding is judgments are based on law, not from hope and noble intentions. I'll give the legal team who are here so that they can respond. I'll start with Stephen.
Okay, the insolvency process seeks to have the interest of everyone who has an interest in the particular company or the particular asset that is being dissipated. So in this particular case, yes, there is a ranking of creditors. There's a ranking from secured creditors. There's a ranking from the costs that the official receiver will incur. And then there is a list. The priority starts from secured creditors, and the last on the list is unsecured creditors. So in this particular case, none of the secured creditors at any point in time even moved the court to seek this liquidation process. So it has always been that all the parties in this particular case would want this matter to be resolved by way of the whole thing, that because even SBM, when they were joining, when they were lending to the ALMA, they were lending because they were convinced that there is a project there. Once it is completed, they also get their money back. So it is not that people say this was from a point of lack of faith. They always thought that there was something there for KCB with the side suites, or even the secured creditors, when they were joining this process, when they were joining this boat that Cytonn was setting sail, they were convinced that there is something here that once it is done, they have put in maybe 700 million. They will also get some interest on it. And then everybody else will also get something. So yes, the judgment, yes, as you mentioned, the judgment is not on hopes and prayers and dreams only, but the judgment that we are seeking from the court in this particular case is the liquidation proposal that has the liquidation route as proposed by the official receiver does not do anything for everyone. It does something for a few people, but for the unsecured creditors, it does nothing for them. But at the same time, even though, as you mentioned, the law looks only is very specific on who has a voice. We are saying that the unsecured creditor is still a creditor, nevertheless. And as this whole process goes on, they have a right to say, okay, if we let it go the way that is currently proposed, I'll get nothing. Why don't all of us as unsecured creditors come up and say, our proposal is this, which gets still something for the secured creditors, but also something for us. So that is our argument. And the Insolvency Act is one of those laws. There are many laws which are very strict in terms of how they are applied. But the Insolvency Act is one of those laws that was crafted with the mindset or with the idea that at the first thing that the court wants to achieve is to save that business. That's the first thing that the court is trying to do. We'll see, for example, even in children's matter, we say that the first thing that the court is looking at is what is the best thing for this child. In the same thing in the insolvency process, the first thing is what is the best possible outcome for everybody involved. So that is the argument that we are making. That is the argument that we continue to make. And as you heard, the previous discussions was that we are looking for a change in the person who is hearing the cases, so that the new person comes in with that open mind to consider all of these proposals. And at the same time, the creditors come together to say, we have also considered this proposal and saying, we want this. It is highly unlikely that the court will say, the creditors have come together and voted on a majority for this particular course of action, and the court to ignore it. I don't know if that gives an answer to the question.
Maybe I can add to that. I think that question is quite spot on. How do we protect ourselves from the banks? Because you see, the bank loans are accruing interest. If you look at ALMA, where SBM has a loan of about 700 million shillings. It's accruing interest at a rate of about 80 million shillings per annum. So when we stay in the courts for 1 year without any movement, their money, what they're entitled to, has increased by 80 million shillings per annum. It's eating into our cake at a rate of 80 million shillings per annum. Okay, so how do we protect ourselves from the banks? Okay, how do we secure our position? One, you want to find a way of having this interest not accruing at that rate. And the only way to do that is to pay off the loan. Okay, we can't pay off the loan now because we can't sell the assets. All assets are frozen by court orders. Okay, so that's why we are looking for a very quick way of resolving and doing this stalemate in the courts to enable the sale of the assets so that these people are paid as soon as possible, interest stops accruing. Secondly, we're also engaging them directly. We wrote to SBM, the CEO. He directed his legal team to engage us. We sought to rope in the official receiver into that discussion because it has to be a tripartite discussion. The official receiver refused to play ball. Okay, But at the same time, so that we are not proceeding just on hope and noble intentions, we have an application in court seeking a court order that says interest on this loan should stop accruing. It's the lawyers for Cytonn are handling it.
I'm still the same person handling it.
Yes, actually, our lawyer here is handling that.
Yes.
All the best to him. We hope he succeeds.
Yeah.
But at the same time, we're also trying as CRC to engage with the bank directly to say, listen, can we have some sort of waiver of interest? And thirdly, how you protect yourself as an unsecured creditor is value enhancement. So if these banks refuse, if they say, no, we are not going to waive our interest, then the way you protect your position is by enhancing the size of the cake. Okay? Where we are telling them, listen, instead of selling Alma as it is, bank, can we finish these 3 blocks that are remaining so that the value is bigger? We can sell at that point, you'll get your money in full, but we'll also get a sizable amount to distribute to ourselves. So there are a number of ways we are taking to approach the issue, which hopefully will safeguard all our positions.
Okay, thank you. On to the next question, James Gavilu. Mediation may work better for us and it will leave us still friends with Edwin Dande. That is okay. Another one, Samuel Mungai. Dande aongee na Sakaja vizuri, mali isonge chap chap.
Thank you.
Who is a secured creditor? That is from MS. Who is a secured creditor in the Superior Homes? Good and Derek.
No, thank you for the question. Superior Homes has no secured creditor. Just like Superior Homes has no secured creditor. It's like Kilimani. It's a property that you can liquidate and get money.
Yes.
Yeah. Cheers.
Okay. Another one from MS. Meeting after meeting, no milestone. Why?
I think we have achieved much. We came in CRC in September last year. And in 10 months, we have been able to, actually 9 months, we have been able to cover so much and penetrate into these issues. So a lot of milestones achieved. We are stronger than we began. Thank you.
Oh, thank you, Chair. Margaret Otolo, thank you for the updates. We have patiently waited this long, and whatever brings us what we put in is welcome, even if there is no profit. However, there are other costs that may be chipping into our final take home. Have these costs been quantified and provided for so that the investors are not surprised at the end? I think, Elashani, you can respond.
Yes, Margaret, in a situation such as the one we are in, costs that eat into the portfolio. First of all, you need the authorization of the official receiver to even incur some of these costs. You see, we are in a situation where the insolvency laws, those are the ones that guide the process. So you can't incur costs outside of that process. And quite frankly speaking, I'm not, unless you particularize what costs these are, it's hard to directly answer. But if the concern is the legal costs, if that is a concern, well, I'm sure the Cytonn team can respond to that better so that they can be able to, because they have visibility on the cost. But I think for me, the issue is what value are we getting from the legal team? It's safeguarding these assets from being sold. If you look at the superior, we stand to lose 600 million.
Yeah.
If we sit back and let it go as it is. So you look at what are you saving vis-a-vis what are you getting, and we take a judgment call.
I also want to add to the cost thing. So, Margaret, if you can look at the DSP at slides 18 and 19, you would get a sense of the costs involved in each of the projects. But what we are saying is that if we go through the restructuring proposal, even after the costs, we would have some monies left, which would pay off at least 100% of our principal. So look at slide number 18 and 19 in DSP. Thank you.
Okay, thank you. Question from Vivian Wekesa. Thank you for the response on the Superior Homes. Question, is it a normal legal practice for a liquidator to get a cut from persons interested to buy an asset? I am not a legal mind.
Anton?
Well, that point was made by Adams, who's not here. But the cut we are talking about is not some sort of.
It's not a kickback.
It's not a kickback. We don't want to disparage anyone's reputations here. Okay, we don't want to say that people are doing back and deals. We don't have any evidence of that.
True.
Do not have any evidence of that. There are some fees that are payable to the liquidator under the Insolvency Act. Okay, there are some fees that are payable. That's under the law. Okay, so probably what we need to get, what we should have gotten from the liquidator is some clarity, because they're not telling us how much they're going to deduct. When we were there meeting them, we unfortunately did not extract that information from them. But there is what is payable under the law. So the question is how much. That is a question that only they can answer.
Yeah, and I think it should go on record that we have not mentioned anywhere in this meeting that somebody is going to get a cut. We only mentioned the disparity between what the CRC is projecting to recover from Superior Homes, which is 800 million, vis-a-vis what has been offered to the OR, which is 200 million, a difference of 600 million. That one does not say somebody has taken a cut, but we raised concerns as to that huge difference and stated that that shows how easily our assets can go at a throwaway price. We didn't mention names. Thank you.
Thank you very much. And to MS, the question is, how many creditors are we? That is the elephant in the room. Whom do we trust? or Edwin? Are there ghost creditors imposed by Cytonn to ensure we don't get our full amounts back? Victor?
Thank you, MS, for the question. There are over 4,000 creditors. So as CIM, we add the data to this. So I think if you are a debtor, there is no need for you to increase your creditors. That will be like shooting yourself in the foot. So there are 4,000 creditors.
I think what MS is concerned about is when they read the court documents, there's the issue of over 25,000 investors. So then they're concerned about the disparity between the 4,000 CHYS CPN creditors and then the 25,000 investors who also include the CHYS CPN and investors from other Cytonn products whose money was also invested in the other projects. So I think that's the clarification they're seeking.
Oh, that is right. CHYS CPN 4,000. Then when you add the other creditors, you are close to 25,000 about
investors.
All right.
So from Shalin Meritu, agree with AK. MS, why can't you appeal against liquidation instead of holding useless fragile meetings? How will this help?
MS, if you were here during the legal updates, you will note that we have already filed 10 appeals, 8 against the vesting orders of Justice Mabea on the Alma Superior Homes Kenya shares, and the other, and also Riverrun. 2 against the liquidation orders that were issued on the 6th January. So of course, everything was already in play. These are just other meetings to ensure that the creditors are on the same page and that the restructuring proposal is put forward to the creditors so that they understand it and they take a view to it.
Okay, thank you, Ike. I concur. That's from Samuel Mungai. Washeke Kimani, we will support you, but please stop framing the restructure proposal as 100% return of investment. Provide more details as to best and worst scenarios and help investors make wise decisions. I think
that's well noted for the CIM team.
Okay.
To review the DSP.
All right. Then from Constance Sarah Oya, of politicians for now, and instead exhaust the legal way out of this quagmire, but restructure, not the war. But hurry up, please.
Thank you. Well noted.
Another one from MS. So far, we are just surviving on stay orders. This is temporary. Can we think of something long-term? Filing a substantive appeal against liquidation?
Again, MS, this has been already done. The first step towards filing the substantive appeal in the appeals that we were filing against the 30th November 2023 ruling and the 17th January 2024 rulings were to seek stay orders because there was the vesting orders issued to the official receiver. So we were trying to curb any action from the official receiver. As at now, we have filed the substantive appeals for all the matters. In 2 matters, we've already even filed our written submissions. We're just waiting for a judgment date. In the other 8 matters, we're waiting for directions on our written submission. So this has been done, and I had answered it initially.
Also, Celeste, you can combine with the Jonathan question. That is after 28th June, what is the timing on the restructuring approach? 6 months, 12 months, 2 years?
So after on the 28th June, we are hoping to get directions on our applications. One of the application was to direct that a meeting be held so that you can vote on the debt settlement proposal. So if we have directions on that, then depending on what then happens, the judge might recuse himself as he has done in a similar matter. He might also not recuse himself. So depending on that, we anticipate, we cannot for sure state the specific period. It all depends on the court's diary, but we will be pushing to have the near instructions granted for the applications for the meeting.
But just to add on that, if if the legal cases are cleared, I think as CRC will hit the ground running as soon as our hands are free, and we work towards the frame time within the DSP.
All right, thank you. We proceed to another comment from Samuel Mungai. A share is a share regardless of whether an investor is secured or not secured. From James on EK's issue about excluding Dande, the risk there is the safeguard of the assets. While his approach has been unpopular, assets are intact. Someone equally as passionate in preserving valuables need to be found and fully briefed on the history and the current state.
Thank you.
May I address something by someone? I think someone you made a point there. A share is a share, regardless of whether an investor is secured or not. That is not correct. That's why we've been trying to tell creditors and investors like ourselves, the first people to be paid will be the secured creditors. So we are not equal with them. Okay, and if you want where the law provides, I think we'll have to give. It's provided in the Insolvency Act. The second schedule provides for the order of payment. Okay, It's about 5 paragraphs long. It's not too long. What we can do is take a screenshot and share with you. If you give us your email, we'll share with you that ranking so that you can see for yourself that it comes from the law. It's not something that anybody is cooking up.
So a share is not a share.
No. The suggestion and the mindset people have is that, you know,
we all share.
We are all okay. We are all at the same level.
No.
The banks will have to get paid first. Everything. Whatever remains, if any, is what we'll be entitled to. And that's what we are trying to. We don't want to get there. So we'll share your email address. We will share with you the extract from the law so that you can read it for yourself.
Okay, thank you. From MS, we are willing to salvage the 14% return through liquidation. Please remove the roadblocks. You have nothing to lose. How much are the CRC members paid by Cytonn as allowances? I think, Chair, you are in the right position to respond. The question is, we are willing to salvage the 14% return through liquidation. Please remove the roadblocks. You have nothing to lose. Another part is, how much are the CRC members paid by Cytonn as allowances?
I don't understand when somebody says they will salvage 14% return through liquidation. You know, liquidation is a process we have no control on, and you cannot. We only the maximum is the maximum we are likely to get is about 14%. That is a non-average through liquidation processes. But now when you say you are going to salvage that, then you are closing highs on the 86%. And we have just seen that in the example we were given on Superior Homes, 200 million vis-a-vis the current value of 800 million. That is what we are fighting. Now, how much are the CRC members paid by Cytonn as allowances? We are not being paid allowances ourselves. When we meet here, we have lunch. We have lunch, and we go back home with our vehicles, fuel, and the like. Much of what we are doing is through sacrifice. Somebody like my vice chairman here woke up around 5, all the way from Garatina Nyeri to come and safeguard his interest, my interest, and your interest. Surely, we cannot say we are paid through that sacrifice. These are sacrifices we are making for ourselves and on your behalf. Thank you.
Okay. On to the next one. From MS still, how much does it cost to host a meeting like this one we are having, and on whose bill? It's more for you to invest our money at zero interest. Okay, I think for the meeting, I am the right person to respond. There is no cost to this one. This is a platform. If you are able to see, whenever you receive it, you'll see it comes from Cytonn Client Services. That is my department. Whenever there is a meeting, a request meeting from any department, whether it's from Cytonn internal departments or from CRC, who request that we like to reach to the creditors like they did, I am the one who handles that one. We prepare, we have this platform. Even if you have been in this platform, even creditors themselves have requested I would like to bring my points. And I always arrange and give them a platform. This is the platform we use. Even yourself, if you feel there is an alternative route you can give us, and you are able to convince creditors, my role, I'll do it. I'll give you a platform, you express yourself. So there is no cost. Anybody can request a meeting through our department, through the email, or you can make a phone call. That is clientservices@cytonn.com. Once you do that one and you say, I am a creditor for CHYS or CPN, and I think I have an idea, I have an alternative, I have a way we can do these things, kindly converge the creditor so that I can give them that idea. That is exactly what I'll do. You'll just give me a few days and I converge that meeting, and you are able to do that. You'll never incur any cost. Thank you. We proceed to another question. This one from Trish. I don't get it. You are saying, is he a corrupt judge?
No, nobody has said.
I don't think
Nobody
has mentioned that one.
Nobody has mentioned corruption about judges or the like. No.
All right. Also, there is a comment from Edwin Dande. Creditors, I had the EK comment that the current scheme board and management needs to leave. Number one, I think EK and those who share his view, and rightly so, need to particularize their concerns. Number two, then bring them to a forum to be ventilated in detail. We are available for a meeting to go through the concerns. Number three, it is unfair to go into a forum and claim that there has been a chain of deception without particularizing them and giving us an opportunity to respond. Number four, remember, we are not just board members, stroke management without a stake. We are owner managers who are also creditors, shareholders, and homeowners. It's not practical to just walk away. Number five, remember, there are those who still have confidence in the board and the management. Over 4 billion in value have signed the restructuring support letter. Do we abandon them? Number six, in summary, I don't think there is a member of the board and management who would have a problem leaving pursuant to a due process. Let us have a duly constituted forum to deal with the issue. That is from Edwin. Thank you. We proceed to MS again. Why are the 4,000 investors not filing proof of debt with the OK? That's, I think she meant, or he meant, OR. Less than 2,000 have, even during administration.
We have no idea.
For this one, we do not have an idea because the OR has his own way of reaching to the creditors. So for us, what we are supporting is restructuring. But whenever there is a creditor who wants to file a proof and they just share in their request that they would like to know how to do so, we have always advised them. We always share a link to the website. You can, if you have not also done and you feel you should do, there is a link for that. You can get it online. If you can't, just ask through clientservices@cytonn.com. We shall share with you the link, then you file. But the OR has his own way of doing it. So from Samuel Mungai, okay, so we have shareholders who are more equal than others. I think that was
answered.
Yeah, it was answered, and that is it. We go to another one from Jonathan. I am doing some basic math. The ALMA has 2 incomplete blocks, which comprise of 2 and 3 bedroom units. I think one of the blocks is 3 bedroom only, if I am correct. What are the current value of the second and the third bedroom units which need completion? How many remain unsold as I do my calculation?
Thank you, Jonathan, for the question. Sorry. Okay. Thank you, Jonathan, for the question. Kindly just do an email. We'll share the details. We don't have the actual ones right now. Just do an email to clientservices@cytonn.com and we'll respond. Just write the email. Just start to the email.
Yeah, you can share. Our email is always clientservices. Let me type it.
We'll have to check and then share that with you, Jonathan.
Yeah, that one. Just share your concern there. We'll be able to share it to everyone. Sorry. There you have it, Jonathan. Sorry for that. And then we go to MS. If we declined to convert to property, how sure are you we will convert to your proposed equity shares?
Maybe I can address that.
Yes.
MS, the proposal for conversion has been presented by the debtor, Cytonn. It will not cast in stone. In fact, the expectation is at some point we'll go into it more deeply, engage creditors like yourselves. Possibly the proposal may change, okay? That proposal on conversion to shares may change. It's not cast in stone, it's just a proposal that has been put forward for our consideration. What we are saying is that we've not had an opportunity as a body of creditors to engage in that thoroughly, and that's why we are seeking the opportunity through various ways, through the OR, to the courts, and hopefully at some point we'll get to have some sort of AGM where we discuss all these things and agree on what is agreeable. You have a right to express your opinion on the share issue, and that as CRC will have to take into account, and then hear the rest of the creditors as well, and agree on a position that is unanimous.
All right, thank you. Judith Oruya, have all the members of CRC filed their proof of debt with the OR?
Not all of them.
Thank you. Another one from MS. What is the value of CIM shares? Is CIM still valued at 82 billion as it used to be?
Thank you, MS, for the question. We'll share the same. Just do an email to clientservices@cytonn.com, and then we'll share the same. What I need to mention on the 82 billion, that was the value that we were to aspire to once we complete all the projects. So we were not valued at that point. But you can share your email and then the particular question, then we'll respond with the current valuations.
Thank you. Kindly share through the clientservices@cytonn.com, an email I've already shared. Another one from Jonathan. If the restructuring is approved, I am able to assist in marketing the ALMA and other sites along with the marketing team. It has been my profession here for 40 years. I am here to help.
Thank you.
Thank you very much. Yeah, I think I've come to the end of the questions which have already been given through our chat box. I'm seeing one from MS. I think it will be the last one. So MS, you're saying, and thank you very much for being active with your questions. How come SBM loan never completed ALMA? ALMA has become a cash cow. You are doing it like public/government projects.
Yes. Thank you, MS, for the question. The reason why it didn't complete, it was not enough to complete. That is the, how do you call it? The straight answer to that. It was not enough to complete.
Okay.
Yeah. Let's save time, guys.
Thank you very much. I think we have done quite a good job. Vivian Wekesa, I think now this is the last question I pick because already we have eaten that 5 minutes into our scheduled time. There is another meeting which already started, but we have inconvenienced them. So the last question I'll take is this one from Vivian Wekesa, that is who is collecting through, I think the rent from Alma.
Alma was already sold. We have people who have possession, so the homeowners are collecting rent for the units that they bought. And for the other units that are not sold, they are not rented out.
Thank you very much. Now at this point, I think I've done my work. I think now I'll hand over because this meeting was called by CRC. I give them the baton through the chair so that they conclude the meeting and they release all of us. Thank you very much for listening. Back to you, Chair.
I think we shall have closing remarks from each of the members of CRC. I will start with good lady here.
So my name is Val. Again, I'm an investor and I'm a CRC member, and I'm honored to be a member of CRC because I can work towards, how we can restructure the whole project and recover the money so that we get at least 100% of our principal. And I can vouch for the fact that each and every member of the CRC, including CIN and Cytonn members, are working towards it. We have the best interest at heart. Just support us in whatever way you've been supporting us. Do not engage yourself in any negative propaganda, which will not help anybody. And lastly, I would say this: start thinking like an investor. You were already an investor when you invested it. Start thinking like an investor. Think about the fact that the OR, despite of our efforts, have not shown any interest to engage with us. But Cytonn management have supported us. What does that tell you as an investor? Think about it. So when you're making the decision to go the liquidation way or the restructuring way, think about the fact that there's one party who's not interested in engaging themselves with the CRC, and the other party is supporting us. So what does that tell you? Think about it. That's all from me.
Thank you. Anton?
Yes, thank you very much. I want to thank the investors who joined us today. We are investors just like yourselves. We are equally as financially pressed as a lot of you are. We are equally very much interested in getting as much of our money back as possible and as soon as possible. We are taking a lot of our, it's a matter of personal sacrifice for us to be here. It's a matter of personal sacrifice. We are not in any way, shape, or form being remunerated for this service we are doing. Okay, all we are seeking to bring to the table and to your information is what we know about this process from our own personal experiences. And if we got time, maybe Vice Chair would have spoken about his personal experiences in liquidation in the circle where he was, in the management. Okay. So personal experiences and our own professions. I'm bringing my experience as a lawyer who's represented clients in liquidation here, because now here I have my own money on the line. Okay, so we have people from various professions. Our chairman here has been in the banking industry credit section for 37 years. He has seen these things over and over again, where other people are affected. Now his own money is on the line. Okay, so we are bringing our efforts to try and resolve this matter. And we're just trying to say, listen, both those who support liquidation and those who support restructuring are seeking the same thing. We are seeking our money back through a sale. The simple distinction is we are saying restructuring is basically a planned sale of the assets, where you first enhance value, then sell at market value and get as money back as possible, as opposed to what we are likely to encounter in liquidation, which is selling the assets as is. As is, those assets are not at their optimal value, a lot of them. Okay? We want to sell them in a transparent manner where we get to know where we get to have a valuation done, where we want to sell at market value as guided by the valuations. In the liquidation process, we are not doing that. The official receiver, no valuations on these properties have been done to date. We were with them in March. They have not valued any property. If they want to sell the shares at Superior Homes, they have not done a valuation on them. So they're basically relying on what to guide the value discussion. Okay. Has there been any discussion from the official receiver on, have you received anything from the official receiver telling you this is the scenario, this is how much you're likely to get, this is the percentage you're like, have you received anything of that sort? No. Okay. By contrast, from the data, at least we've received some document called the DSP, which we're engaging in. It's not cast in stone yet. We are seeking all manner of all investors to come in, share their advice, Jonathan, you've talked about being in the industry for 40 years. That's a good thing. Ike, you mentioned, quite some very valuable points, Trish, as well. So we need all of us to work together, share ideas. We can make this document, the DSP, better through sharing ideas, and then we can agree on the way forward and get money back into our pockets. So those would be my fairly lengthy closing remarks. Thank you.
Thank you, Vice Chair.
Thank you for your joining us today. And thank you very much if it was your first time. We as the CRC, we highly appreciate that, because we can be able to see that we are going somewhere. What I can see is that, as the Bible says, I will keep on quoting the Bible because I am a pastor myself with over 11 years of experience, and I have a church that I run daily. The Bible says that two are better than one. And one of the reasons is that they will get a good reward of their labor. And this is one of the areas that it is well applied. Once we come together, we have one vision, we have one way, we have one destination. Finally, we shall be able to make it. Because even God himself will reward us. And I have also an experience, because previously I'm a retired officer and have worked with the Ministry for Cooperatives for over 36 years. About 28 years as a manager, and 7 years in lower classes. And in these 7 years, in 1996, I happened to be in our giant Madeira Farmers Cooperative Society in Nyeri, Madeira, which was liquidated in the year 1996 to 1998. And one of the ways, or one of the issues that entered in my mind is that me myself, I was member number 28146, and we were paid half of the money that was required to be paid to us, because the society dealt with coffee processing and selling and the payment to members. The first payment we were paid half, and the second payment went down to the drains. Members could not be able to get anything because the money went to payment of workers payments that were not fully paid. Debts were not completely paid, and even members could not get the last payment for their produce. From 1996, my memories are vivid. I know everything that transpired in that time, and therefore that one forms a big reason to me, because I have the experience and know what the liquidator dealt with the product, with the properties and the product that was there, and the members could not be able to do anything with the liquidator. They had no say, so they had to wait. Their hard-earned investments go down in drain without any say. I know that one applies even today. We don't have much to tell the liquidator. We have nothing much to offer to the liquidator. He's a lone rider in this vehicle. So once we join together, you and us, will be able to vote ahead and seek for redress, and that will be given opportunity to be heard and control our investment, which means we shall be able to get the best out of it in comparison to the liquidation process. Thank you.
Asante, Vice Chair. I think mine is to thank everyone who has joined us today. Our dear fellow investors, Asante Sana, you have sacrificed your time to join us. Thank you, our legal team, Mari, DH, and the CIM also legal team. I think together we formed a very strong team because we are fighting for what is rightfully ours. And to sit down and watch our efforts going down the drain defensively without any say, I think we'll have ourselves to blame. We have the best opportunity now to rise up and fight for what is ours. When I invested with Cytonn is about 5 years now, or 4 years. For the last 3 years, and many of you are like me, I was in darkness of what was happening. I only came into light last year. Realized, hey, my investment is going down the waters. And I woke up. I am sure many of us have also woken up and realized what we were about to lose. And a very good example has been given to us today. Life. Superior Homes shares, which are worth 800 million, being offered, or somebody wants to buy for 200 million. That is the kind of picture we have for our assets. And as we sat down and grouped ourselves to CRC, guys, and with the support of our lawyers, there's nowhere we cannot go. And I'm glad somebody has alluded, there is an office, White House, where we can go. It's a public office, we can also go there because we are fighting for what is ours. Our investment is not a drop in the ocean in this market, Kenyan market. It's huge investment. And anybody, any politician, any leader, any institution will hear us. Na tutafika hapo tukiwa pamoja. What I'm asking is, please support us, have confidence with us. I know many of us are hedged, many of us are hailing, but we can fight after the last breath. And I'm sure even if we go, we have people behind us who can continue and soldier on. Mungu ambariki sana. And thank you. Bye-bye.
Thank you very much. Now I think we have come to the end of the meeting. And I apologize. I see there are a few questions probably we are not able to respond to. You can redirect them, or I'll just assign our financial advisors and client services to have responses to you directly. That is SMS and probably Kimani and any other person. And also feel free to reach out to Cytonn through the client services at cytonn.com or through our financial team led by Victor or Uma. We can be able to respond. And if you feel you need assistance or some response from our legal team, we shall do so. Or also you may need assistance from even the CRC team members, we shall also do that. Thank you for being patient with us. I know we have taken long, but it has been very, very successful, and I thank you very much. Until next time, I think we'll end this meeting at 1:52 p.m. Thank you.